Yes. Yes. Uh, these items I am not joining. Just. Okay. 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 Yes. What order? Garnish order. You are the debtor or you are the garnishee? Okay. Monday you will get a walkover. Monday you'll have to argue at the gate. Huh. Very difficult. This different on these days. You can try. Okay, give it to the court master. He'll make adjustments. Give it to the court master. Huh. Yes. 52. You're for respondent. Okay. Okay. You say A Das, the counsel, has submitted that he has been instructed to appear for the respondent in the matter, and with the consent of the other side, he prays for adjournment. Prayer is allowed based after ensuing vacation. Interim order past release stands extended till the next date of listing. Yes. Okay, get it. Criminal revision. Criminal, do I have the bench of criminal? I don't know. I don't know, I'm not aware. Criminal? No. Yes. Forty-two. You're for the? Okay, you're taking consent of the other side? Okay. No. Without consent, don't make a prayer. There's something it disturbs me. If you don't have respect for your own brothers who are in the other side, then what respect you will have for the court? No. First duty is towards your brothers. When you are praying for an adjournment, and you know this, when I am taking up the old pending matters, other matters are unlikely to reach in the bottom. You make the other side sit down here for the entire day, and then he finds that the matter is adjourned. It's something which is not happening in this court. Without consent, no. Yes. $11. Okay. Okay. When? Monday, Tuesday? Okay, item 45, quote number 11, distance and so. 50, 55 supplementary. Yes. Okay, correct. Yes. The what you call what is the status of that interrogatory application for condemnation or delay? Okay, get it. If they have appeared, get it. Get it listed. Forty-seven. Okay. List after vacation is paid for by land counsel for the petitioner. 47. Okay. No, we are not adjourning. Let the matter is, then we will see. All pending matters you are not adjourning. No, we will see when the matter is there on vote, then we will see. We are not adjourning all matters. We have to give answer. Yes. Okay. You will inform the other side. You're for respondent. You're for appellant. Okay. Okay. Miss R. Chhetri, counsel for the appellant. With consent of the other side, has submitted that the appellant number 1 has expired. An application of substitution has been filed, which is not on record. So accordingly, this is the matter after vacation, along with the interlocutory application for substitution.
Top of the list, item 1.
Seven 11/2000. That was issue number in the trial court. Issue number 4. No. That was issue number 4. That data. This suit is by the, this appeal is by the defendant. Where is that relevant discussion on that letter? Seven, 11, 2000 letter. Immediately after the issues. Yes, after the additional issues, my finding there of so. My 22.5. Ah, yes. That is playground with 27. But Mrs. Burman, if that is the substantial question of law, this is a question of fact. Your appeal would not be maintainable on this, on the only one ground. There's nothing here because this is something 711. I was missing it. When this having read the discussion on 711 2000, there's nothing on record that you have denied that letter. So it becomes an admission. There's no substantial question of law involved here. Any of you have a copy of the cross-examination of PW1 on that letter? Yes. হত্যা নয় যে 7/11/2000 আরো what is this কথা কোনো ঘটনা বানা সেটা there is no cross examination on delta. No, not that. I am reading, I am interested in this because of the substantial question of law. The question of law is whether the lower appellate court was justified in declaring this suit solely on the basis of presumption of letter dated so and so. That is why only one thing is relevant in this appeal. Suit was dismissed. Suit was decreed. Now, I presume that suit was dismissed because of the substantial question of law. The question is whether the learned first appellate court. So that has to be dismissed. Otherwise, it would have been concurrent finding. Suit was dismissed, has to be. At times, certain shortcuts I take. No, apart from that, there is nothing. No, I've seen that, I've read that. Only I was missing is that evidence of discussion on evidence of 711. That's why I refused the adjournment. Because some time is taken away in reading the second April brief. Okay, sorry, in some better case. Had Mrs. P. Burman, London Counsel for the appellant, and Mr. D. Mazumdar and a senior counsel, assisted by Ms. D. Devi, counsel for the respondent. The appellant herein is the defendant in the suit. By filing this appeal under section 100 CPC, the appellants, appellants have assailed the first appellate judgment and decree dated 24/7/2009, passed by the learned civil judge Dibrugarh in title appeal number 50 of 2006, by which the appeal was allowed, and the judgment and decree dated 21/7/2006, passed by the learned civil judge within bracket junior division bracket close number 1, Dibrugarh, in title suit number 108 of 2002, by which the suit was decreed as dismissed, was set aside. Next, this appeal was admitted for hearing by order dated 16/11/2009 on the basis of the following substantial questions of law. Question of law. Number 1. Only one question. Like, next, the respondent plaintiff had filed a suit against the appellant, praying for decree of declaration that that the plaintiff had right title in interest over the suit land, and that and for a declaration that the defendant appellant had no right and authority to cause disturbance, public interference, and not to infringe the right title, interest, and possession of the responsibility in respect of the suit land, and for recovery of khas position by awaiting the appellant defendant permanent injunction and other reliefs. Full stop. The suit land is a plot of land measuring 4 bigha, 0 katha, 0 acre, covered by that number 355, 391, and 392 of NLR grant number 26 with a under Bandung, BAGDUNG, Moza, TO Panitola, PANI, TOLA, in the district of Dibrugarh, along with a room made of bamboo wall and CI sheet roof with different boundaries as described in the schedule to the plaint. on 7/11/2000. A letter was written by Sibanath Barua, Sibanath Barua, Barua, Balindranath, Baldra, Nath Barua, sorry, Rajkua, and Sri Kamal Talukdar. As representative of public and members of a steering committee, STEERING, steering committee, wrote a letter to the senior personal manager of the respondent to inform that in a public meeting held on 2/9/2000, it was resolved to establish a secondary English medium school from session 2001 and to request the Panitola Tea Estate for releasing a plot of land measuring 8 bigha covered by Dak number 354 of Nalini, NALINI, Hulla, HULLA, Bengali Gaon, Bengali Gaon. Full stop. Thereafter, on the same day, thereafter in the month of April 2002, attempt was made by those persons to encroach upon the suit land, which was reported to the police, and proceedings under section 145 CRPC was drawn up. Mr. Hava, a bamboo wall room with CI sheet roof was erected by the respondents and affixed a signboard in the name of Divine, DIVIN, Academy School. On 15/12/2002, another attempt was made to raise construction over this footland, and therefore the respondent filed the suit. Next, the respondent, the appellants, those defendants contested the suit by filing a written statement. Claim that they are in occupation of the suit land since with consent of the original owners. I, Messrs. Parshuram, PARSHURAM, T full stop, E full stop, of Messrs. Chunnilal, CHUNILAL, Pannalal, PANNELAL, and company, since long and openly. It was also claimed that the land did not belong to the respondents. Nor it was a playground or a grazing land. And that it was claimed that the residential quarters were standing on some other land near this woodland. So it was also projected that the letter dated 7/11/2000 was not in respect of the woodland, but for some other land. And it was denied that any construction was set up or any attempt was made to enforce the land. And accordingly, prayer was made to dismiss the suit. Stop. In course of trial, the learned trial court had framed seven issues as well as an additional issue, number 8, as follows. Flagging. The plaintiffs examined one witness, namely Deepak Sharma, DEEPAK Sharma. And he had executed 6 documents, being defendant's letter dated 7/11/2000 within bracket exhibit 1. This you'll find in the second file, LCR. Like, so let me say that you will not have to find it. Then certificate of the circle officer dated 12/6/2000 within bracket exhibit 2. Revenue payment challan within bracket exhibit 3, 4, and 5. And map of the plaintiff's land showing the suit land within bracket exhibit 6. The appellant defendants, appellant's defendants had examined 2 witnesses, namely Balindra Nath Rajpur within bracket DW1, and Mohim Gogoi, MOHIM Gogoi within bracket DW2. However, no documents were exhibited. Just clarify, in the LCR, I am finding two DWs. Examine. In the judgment at page 26 type copy which is given, there is only one. No, LCR has two. Was it expunged? DW2 was expunged. Then DW2 must have been expunged. DW2 was filed on 6/5/2006. No, then, but what happened? No, I'm halfway through it. However, it appears from the order dated 7/6/2006 that that after cross-examination of DW1, the stage of defendant's witness was closed by the learned trial court, and the case was fixed for argument. Because the records has to be straight. Only one. In respect of issue number 1, as to whether this is cause of action, in respect of issue number 1, the learned trial court had held, had decided the same in the affirmative and that there was cause of action for the suit. In respect of additional issue number 8, as to whether the suit is bad for non-joinder of parties, it was held that it was held that due to non-impediment of Mrs. Chunidal, Pannalal and company, the suit was bad for non-joinder of necessary parties. Because in the opinion of the court, the suit could not be proceeded and decided in the absence of the said, the said joint owner of the land. First off, in respect of issue number 4, it was held that the PW1 had clearly admitted that Panitola Tea Estate is not the absolute owner of the land. Measuring 1602 bigha, 1 katha 0 lecha, which includes the suit land. And accordingly, it was held that the plaintiff was not the absolute honorable sultan, and the issue was decided against the respondent plaintiff. So in respect of issue number 3, it was held that the PW1 does not know when the apparent respondent had occupied the suit land, and therefore his plea in the plaint that the suit land was occupied by the appellant in April 2002 was found not acceptable, and accordingly the issue was decided against the respondent plaintiff. So in respect of issue number 5, the Learned Trial Court held that the appellant's defendants had been occupying the suit land prior to April 2002. However, it was observed that the appellants dash defendants had failed to prove the vague term inverted commas since long. So in respect of issue number 2, in view of discussion and decision on the issue number 6, it was held that the suit was not maintainable. Issue number 2, last was issue number 2. In respect of issue number 6, in view of discussions and decision on issue numbers 3, 4, and 8, it was held that the plaintiff was not entitled to decree as prayed for, and accordingly, in respect of issue number 7, the court held that the parties are not entitled to any other relief, and accordingly, the suit was dismissed without cost. Next para. Appeal against the judgment and decree passed in the title suit was preferred. The Learned First Appellate Court had failed to formulate any point of determination as required under Order 41 rule. Within bracket A. Which is otherwise unacceptable. Nonetheless, all the issues were revisited by discussing the evidence. So, as this appeal was filed on 5/11/2009 and admitted for hearing on the substantial question of law referred above, comma, without intending this to be a precedent, comma, the non-framing of points of determination could not vitiate the first appellate proceedings in view of the discussions on all the issues and revisiting the same with discussion on evidence. So the learned first appellate court, next para. Because the additional issue number 8 first. The first appellate court considered the statement of PW1 to the effect that the record of rights discloses the name of Panitola Tea Estate as the owner of the land in question, and also referred to the averment made in the written statement by the appellant's defendants that the suit land belonged to Mrs. Parshuram Tea Estate of Mrs. Chundral Panalal and Company. Coupled with the fact that the appellants had not submitted any documents. Appellants as defendants had not produced any documents which will prove that the suit land belongs to Mrs. Parshuram Tea Estate of Mrs. Chundral Panalal and Company, comma, found that the respondents plaintiffs, respondent plaintiff had successfully established by oral and documentary evidence that this woodland belonged to the plaintiff. And according to the issue on according to held that the suit was not bad for non-general necessary party. Resultantly, issue number 4 was also decided in the affirmative in favor of the respondent dash plaintiff. This judgment is very clumsy. But I have not found a clumsy order like this. What is trying to say? What is discussing? Appellate court. And what is what are the findings? Can't be deciphered. No, because this gives an impression that he took the decision first and discussed it later, and then writing whatever he wanted to. Huh? That is the impression. No, that is okay. Take up one paragraph and end it there. In order to arrive at a finding that the plaintiff company was the owner of the land, reliance was placed by the learned First Appellate Court on letter dated 7/11/2000 by the defendants to provide a land for establishing an English medium school. And therefore, the said letter was also accepted as an admission on part of the defendants in so as to affirm the title of the plaintiffs over this land. So, the learned trial court, in respect of issue number 3, the learned appellate court relied on the map of the suit land within bracket exhibit 6 to arrive at a conclusion that the suit land, including the encroached area, was described therein, and accordingly held that the documentary evidence will prevail over the oral evidence. And on the basis of exhibit 3 and 4, it was held that the said documents proved that the suit land belonged to the Panitula Tea Estate And the first appellate court had also referred that the DW1 did not exhibit any documentary evidence to show that they were lawfully holding this woodland. In this connection, reliance was also placed on the 145 proceedings drawn up by the executive magistrate, being case number 162 of 2002. And in view of the statement made by the PW1 that the land was encroached by the defendant, the suit land was encroached by the defendant and illegally, and they illegally constructed house on the suit land with bamboo fencing. Bamboo wall and sheet roof with signboard of Divine Academy School. Held that the appellants were in possession of the suit land. Moreover, in this regard, reliance was also placed in the cross-examination of DW1, where he had not mentioned that, admitting that he had not mentioned in the evidence on affidavit that on which date the Divine Academy School was established. And accordingly, it was held that held in respect of issue number 3 that the defendants were occupying this woodland since April 2002 and not since long. In view of the discussion on the other discussion on issue number 3, it was also held that in respect of issue number 5, that the defendants had been possessing this woodland since April 2002 and not since long. I said this part put it earlier. There's only one. Accordingly, in respect of issue number 6 and 7, it was held that the suit was liable to be decreed and the defendants were liable to be evicted from the suit land in terms of prayer made in the plaint. Next paragraph. The learned counsel for the appellant had pressed on the positive points that the learned trial court had referred to for declaring the suit. And it was submitted that the judgment and decree passed by the learned trial court was liable to pay appeal because of non-joinder of necessary party and in absence of the ownership, the suit land could not have been declared in favor of the plaintiffs and decreed for eviction. In support of our submissions, the evidence of the PW1 and DW1 was also referred to. Full stop. Next paragraph, for contract, the learned senior counsel for the respondent has also made his submissions to support the first appellate court judgment and decree. Next paragraph. The limited question to be decided in this appeal is limited to finding out whether the appellate court was justified in declaring the suit solely on the basis of presumption of a letter dated 7/11/2000 written by the defendant to prove that the land was encroached upon by the defendant. Stop. In this regard, the court finds that there is no dispute that the land which has been encroached by the, which is stated to have been encroached by the appellant defendant belong to Panitolati estate. Just the ownership of the land in the name of Mrs. Chunilal Panalan and Company was a question of fact to be determined by the learned trial court. Full stop. Notwithstanding that Mrs. Chunilal Panalan and Company, as projected by the appellant, was the owner of the land. But the question to be adjudicated is whether the manager of Panitola Tea Estate could have filed a suit for eviction. Full stop. If the So it is in this connection, it is noted that it is not in dispute that the respondents, sorry, the representatives of the appellants whose names are reflected herein before had written a letter dated 7/11/2000 to the senior personnel manager, Panitola Tea Estate. Stop. Therefore, having written to the Panitola Tea Estate to provide land, the appellants have admitted that the Panitola Tea Estate had the authority to deal with the land under its tea estate. First of all, the appellants had not taken steps to summon representatives from Mrs. Chunilal Panalan and Company to establish that the respondents plaintiff had no right to sue the appellants for eviction. Under such circumstances, the court finds that the decision of the learned First Appellate Court in declaring the suit on the basis of 7/11/2000 within bracket Exhibit 1 cannot be faulted with. So notwithstanding who was the owner of the land, comma, the suit land was demonstrated to be the land within the Panitola Tea Estate. Which and that Panitola Tea Estate partakes the character of a firm. And therefore, the person who is in possession of the land would have a right to evict an encroacher, although he may not be the true owner of the land. Full stop. Therefore, comma, the court is of the considered opinion that the London trial court had committed grave error in not considering the fact that even a person who is not a title holder but had a right over the property in question had a right to sue an encroacher, as it affected its right over the suit land. Therefore, the finding of the London First Appellate Court on additional issue number 8 as well as issue number 4. This is trial court, no? Trial court, appellate court, trial court, appellate court is affirmed. Next paragraph. There being no perversity in the finding of the London First Appellate Court, as the appellant has not been able to establish its right to stay over the suit land, comma, the court is of the further considered opinion that the issue relating to interpretation of the letter dated 7/11/2000 is an issue of fact and not a issue relating to perversity in the finding of the London First Appellate Court. And therefore, a finding of fact would not be interfered with in the absence of any perversity in the finding of the First Appellate Court. Full stop. Next paragraph. In view of the discussions above, the court finds that the London First Appellate Court had rightly held that there was cause of action for the suit which was maintainable, and as the appellant had encroached the suit land, comma, the appellant was liable to be evicted. But Mr. Mazumdar, I have to give a rider in respect of issue number. Issue number 3, right title and interest. The right title and interest. Issue number 4. This 4 would be with a rider that this would only operate qua the defendants, nobody else. This is not a judgment in rem. Title court could not have declared. No, Kamjari is in the name of Chunilal. But it's in the name of Chunilal. For Parshuram Tea Estate and.
Both are there.
But you are Russell Tea Estate.
Yes, this Panitola is also mentioned.
You see, Panitola is a fictional name.
Yes.
It does not have its own entity.
Yeah.
It is just because of the Tea Act, where it's a requirement that you'll have to operate in the name of a tea estate. You are having it, but title could not have been declared. This is not a title suit qua this Chunilal and others.
And that is there.
So this is, we'll just make it clear that this should not be declaration in them.
So far, dependent, I think it is quasi dependent.
Call it defendant. But this could not have been done.
There's one thing. The school management is now totally different. And they will say it was for the main dependent, not against us.
No, it's defined that we can't say anything. You're not asked for substitution.
Divine Academy.
Divine.
Ah.
So who will be the managing committee?
What Divine Academy that suffice.
Hmm.
Divine Academy.
Nonetheless, comma. In view of the entries. However, comma. This next para, huh? Okay, in respect of issue number 4, comma, the court is inclined to clarify that in view of the contents of exhibit 2, comma, the what is the name of exhibit 2?
Certificate.
Certificate
Certificate.
of the circle officer dated 12/6/2000,
2002.
2000. Uh, 2002. 2002. Earlier I've said 2002. It will be 2000, 2000, not 2000, it will be 2002. Comma, the court is inclined to provide that the declaration of right title interest as provided by the learned First Appellate Court would be operative qua the
Certificate is in the name of both. Panitola is also there.
no, you see manager again.
Manager.
That's why I'm not going into all this.
Manager.
Qua the defendant, namely Divine Academy School. Divine Academy School.
Manager.
What is the name?
Divine.
Divine Academy School. According to this, the substantial question of law is answered by holding that the learned trial court had, the first appellate court had not committed any error to decree the suit solely on the basis of the letter dated 7/11/2000 within bracket exhibit 1. According to this appeal fails and the same is dismissed. First of, however, under the circumstances, the parties are left to bear their own cost for this appeal.
Right.
Next, let the appellate decree be drawn up and the NCR be sent back.
My friend,
Oh, sir. Mr. Dilip Mazumdar, assisted by Mr. D. Nath,
all right.
advocate. Yes,
Item 224.
no, he'll be out of station because he is afraid of her. Once she comes again tomorrow, again he will be out of station.
We are connecting network here. And sister will go for their sister go for this side is brother, sisters and that side of the brother.
Fight between the sisters, two sisters and the brother,
Brothers fight.
descendants of the brother.
Fighting for their sister go for.
That is a tradition we are following since Mahabharata.
Yes.
So you have to follow some traditions. Huh? So we don't find fault with the brothers fighting. It becomes a lawyer's paradise to appeal. How many miscases are there? I think 7 or 6 or 7. IAS.
Some of them have died in the meanwhile.
No, whatever be, but when this fight is generated to appeal, 6 or 7 interlocutory applications, lawyers must be happy. These people don't want to sit together and discuss.
An effort was made, Melod. There was a mediation attempt a few years back. That failed. Then
Okay.
another sister passed away. I think Aditi Sharma passed away in the meanwhile.
The one sister is.
One sister is alive. One of the petitioners is alive, Dipti Bhatt Thakur. The other person has passed away in the meanwhile.
He was unmarried. Now, one sister and the other. I don't know if he wants to.
I don't have instructions, Melod, for that. Only to the contrary.
This there was a will. Two will. One by brother and one by mother. One by father and one by mother.
This land was bought in auction sale by the husband of,
Properties are different.
Okay.
Right.
the second appeal, Melod, it was bought in auction sale.
In the will. Right.
Okay, so it is being claimed that in the land which is purchased by auction sale, there the plaintiff is a permissive occupier. That is the case.
That is their case.
And you have no counterclaim there.
Beg your lordship's pardon.
There is a counterclaim
There is one.
for eviction. Okay. And in the will, what has happened? The will was probated. But then why this, why you are contesting this interstate appeal? Why suit for partition was not filed? So even if this appeal is decided, whatever way, but that division of the house still remains. So division of house now would only be by giving money. The shareholders must, in fact, if they sit across the table and think about compensation in terms of money, that will be okay, because if the will is probated in favor of, say, let us assume that there are three brothers, two sisters and one brother. No, whatever be, but the legatives would remain, except for one sister who is unmarried.
She passed away. in the
She
meanwhile.
he passed away.
Fine.
Okay. Now, so division of one share is gone. So there's division of two shares. Even if we decide this appeal, this interested appeal, can the property be divided? No. And there's another principle with the Transfer of Property Act, that anything attached to earth would follow the earth. So if the will is probated in favor of Sharma's client, then the house follows with it. Otherwise, you see, we arrive at a situation where everything would be divisible. Now you will say that there was a mango tree in the land. In the will, there is no reference to mango tree, and therefore divide mango tree 50-50. Somebody will come, no, not only that, there was also a rose plant. So rose plant is also had to be divided, but that can't happen. Anything attached to earth. So if that is the only issue, I think we can decide this matter.
Part that taken for one.
No, you see, that's the, if that is the only reason in second appeal, then all this substantial question of law would fail. Nothing would survive for decision, because the first substantial question of law is whether the appellate court committed error in deciding title appeal number so and so without following the procedure laid in order 41 rule 31. Now this 2009 matter at this stage 41-31, we can't send it back, because the perversity in the finding of the issues is not raised. The second is whether the appellant plaintiff is a permissive occupier. So if there is a counterclaim, even if you are a permissive, what do you call, permissive occupier, still you have to give way for eviction.
It is the, it will be the, yeah, the place, and the sister is having that. She was unmarried, so.
Because if once we admit it is a permissive occupier, then what survives in the appeal? It is only this volume. No, Monday you see, we'll be close to Puja vacations.
Partner,
No partner business. Whatever little is remaining, it will also go away. By keeping it parted. But next time we make it clear that no adjournment on the ground of advocates. If you are not there, we decide the matter, even without it. No, that's okay. But next time I make it clear, if Lawyers are not there, without assistance, we'll hear it. But both sides are really represented. On the prayer made by Ms. P. Bhattacharya, and counsel for the appellant, the matter stands adjourned today. List. Next, it is made clear that if on the next date, that on the next date, no adjournment shall be granted, and even if the learned counsel for the parties are not ready for hearing, the court would dispose of this appeal, even without the assistance of the learned counsel. As this is a appeal of 2009. Next list in the week commencing 2011-2023.
The date may be fixed. The date may please be fixed.
No, we don't know. So you see, every matter is being adjourned after vacation. What happened? What would happen if I give a date? We don't know. We'll not be able to manage the board. So after vacation, it will be a vague date. I've given a week. They will adjust and list it.
Daily list item 5.
Timing. Just. Okay. After some time.
Item 6.
Yes. You are the plaintiff. Your plaint was returned.
Then the tenant cannot sell a suit before the planning. It's for the on I find identity number 1 to 65 into 1. For declaration, that I will tell you
Just a moment. Just a moment. Give a scroll for Mr. Dipankar Nath, Senior Government Advocate. Dipankar Nath, Senior Government Advocate. Just wait for some time.
Item 7.
Yes. After some time. Okay. Oh, yes.
They got married in 2013. Both of them were belong to a three men. They used to particular illegal component. And then 2013, they registered in marriage. Taxation, this was made. Very obviously. But subsequently, the wife has filed a case, the husband has filed a case for restriction for legal rights. And wife also filed a for knowledge of. the-
Just tell us how many adjournments you have taken.
Yes, correct. It's the only method for your doctor. That I pray with your doctor. The last order was made. That is the page 4279. But hopefully that marriage certificate was think by the criminal case, I was the one. That's how in spite of the time again admission that the police could not produce that. So we pray that a limited time will be given matter, and by this time it is not possible that we will go.
It shows that it has been seized in a criminal proceeding. Where is that? No, some document to show that it was seized by the police.
There was a criminal case, we have mentioned, but yet.
No, mentioning will not do. Well, there has to be specific. We must know where it is lying. Because if the document was seized there would be a seizure list. If there is a seizure list, it would be there.
Because these from, very well.
No. You don't have a certified copy of that.
But I will mention your. And last occasion, why we, because there was an agreement on their side.
You are the plaintiff.
And no, I am the respondent here. But my case has been put in the, kept in evidence. because
No,
the court said not that-
No, you are the plaintiff in the family court.
Only the court, justice of Punjab, I was the plaintiff. But it is a matter related to the knowledge of the marriage. But while my case has been kept in evidence. By the family court that the voting matters are of belonging to same party, so let the party decide. But the knowledge is good one.
Nullity is filed by the wife.
One. But I take your order page, order dated 7/9, page 42. Because the wife for everyone is also very good. No one is regardless has come, she has become the free that it is a forbidden marriage. Only one of the
No, that will not be permissible. You see, I am taking so time because I have, what do you call? It was not very clear. Please come to page 20. Last, first paragraph. That the registration of marriage held on so and so and the so and so under so and so by so and so certificate. So therefore, this certificate was produced by the wife in the court when she is praying for decree being a nullity. That cannot be presented without the certificate being there. No, you see, this becomes a document which is otherwise you could have taken a secondary evidence and proved it. If the document is not there for 2013 till today, the suit can't be kept pending.
I know it's my fault of either areas are taken to dispose of the matter. So what then in that.
No, I won't give any observation. Because once the DW is closed, we can't reopen it after several adjournments taken. We can't reopen that.
My right is, I have no right to claim now because I.
No, you see, you see, the plaintiff, the wife, would have proved that certificate if she is the plaintiff. And therefore you have crossed her on that document. Now, just because of the origin, if you keep it pending for so long, it affects the right of the wife. It can't be permitted. No. No, you see, it's a revision. I am only jurisdictional error. There's no jurisdictional error.
The judiciary is not.
No, it's just, Vishwas, we can't permit that. Only, no. No, because this should be a floodgate. We're not doing it. No. We can do another thing. We can record your submission that you want to withdraw it and move the court for what you call recalling of this DW. And we just close it without any observation of the court. Because if I make an observation in the while dismissing it, I have to write something.
Welfare of both the sides, right?
No. For that, you can pray before the court for mediation. But when DW is closed after 10 years of litigation.
Probably it is not only for the fine, it is for the wife also.
No, maybe just,
10 years.
no, we are not saying anything. We are not commenting on that. But now we are 10 years down the line. No, we can't permit that. If jurisdiction error is not there in 227, we can't interfere.
Whatever might be the possible one, can be passed.
No. You have to dismiss it. Mr. S.C. Vishwas, and counsel for the petitioner. Next paragraph. By filing this application under Article 227 of the Constitution of India, read with Section 151 CBC, the petitioner is assailed. The petitioner, who is the estranged husband of the respondent, has assailed the order dated 7/9/2023, passed by the learned Principal Judge, Family Court, Kachar, Silchar, in FC Civil number 152 of 2013, by the said order, the learned trial court had rejected petition number 2185/3 and 2184/1, by which the petitioner had prayed for calling of the records seized in connection with GR case number 1654/2023, which is pending in the Court of Learned Judicial Magistrate First Class Silchar. Where is that? Where is that petition? Yes, your petition. Where is that?
340.
Forty. GR case now also pending in the Court of Learned Judicial Magistrate First Class Silchar. To prove the genuinity of the marriage certificate in question. First off, the Learned Trial Court by closing DWs had fixed the matter on 19/9/2023 for argument. Next, the Learned Counsel for the petitioner has submitted that during the pendency of the proceedings before the Family Court Kachar Silchar, the respondent wife had lodged an FIR pursuant to which the original marriage register was seized by the police in connection with Silchar PS case number 947 of 2013, corresponding to GR case number 1654 of 2013. Accordingly, it is submitted that the original marriage certificate was required for the just and proper adjudication of the issues between the parties. Full stop. Next paragraph. The Learned Counsel for the petitioner has also submitted that at whatever cost the court deems fit, one opportunity be granted to the petitioner to plead evidence in the case. Next paragraph. From the materials available on record, it appears that the respondent has filed a petition under section 25 within bracket Roman small 3 of the Special Marriage Act to pass a decree of nullity for annulling the marriage which is allegedly stated to be fraudulent marriage registered on 30 January 2013. Full stop. It also appears that the petitioner has also, prior to that, the said proceeding is FC Civil case number 152 of 2013, which is pending before the Principal Judge Family Court Guwahati, Kachar Silchar. Next paragraph. In the meanwhile, the petitioner has also filed an application before the Principal Judge Family Court Kachar Silchar under section 9 of the Hindu Marriage Act for restitution of conjugal rights, which is registered and numbered as FC within bracket civil case number 101 of 2013. Full stop. Next paragraph. Apparently, it appears that on an FIR filed by the respondent, Silchar case number 947 of 2013, corresponding to GR case number 1654 of 2013, has been registered, which is being tried before the Court of Judicial Magistrate First Class. Full stop. It also appears from the contents of the order dated 4/2/2023, it appears that the learned Principal Judge Family Court Kachar, Silchar, had allowed the petitioner to take steps for service for production of the documents from the Office of the Marriage Registrar Kachar. Full stop. Apparently, focus of the court, although there is no material available on record, but as the petitioner is found to be aware of the proceedings of GR case number 1654 of 2013 before the Court of Judicial Magistrate First Class, the presumption is to the effect that the petitioner knows that the original marriage register was seized by the police, and the same is in the records of the Judicial Magistrate First Class. Nonetheless, the petitioner had filed an application before the family court and the learned Principal Judge Family Court by order dated 4/2/2023 allowed the petitioner to take steps to call for the original record from the marriage registrar Kachar, Silchar. Full stop. Be that as it may, it appears from the order dated 7/7/2023 that the respondent, i.e. the estranged wife of the petitioner, had submitted the certified copy of the marriage certificate number 49 of 2013, dated 30/1/2013, before the learned family court, which was kept on record. The official witness from the office of the district registrar was present. However, he had not brought any written authority to depose in the case. Full stop. There is nothing available on record that the that there was any impediment by the impediment on part of the petitioner to take leave of the trial court and prove the and proves his case through the certificate copy of the marriage certificate. Full stop. It also does not, there is also no reason assigned as to when the marriage register is seized by the police, how is marriage registrar could have produced the original. So therefore, the court finds that the steps The procedure adopted by the petitioner to call for the records from the marriage registrar was was a calculated step. It appears that the Learned Trial Court, after granting certain adjournments by an order dated 30/8/2023, had provided that adjournment was granted by putting the petitioner to notice that if evidence of DWs was not exhausted, the court would have to close the DW on the next date. So therefore, and the prayer for adjournment was refused. By order dated 7/9/2023, the court does not find jurisdictional error in closing the DWs. In the impugn order, the Learned Trial Court has recorded that the case was of the year 2013, and that since 18/7/2023, the case was fixed for further DWs. And therefore, the two petitions were rejected. That's all. Be that as it may, as the court finds that the certificate copy of the marriage certificate is already before the board of the, he's already on record of the Learned Trial Court. Come on. Has already been brought on record as a trial court. So therefore come out in considering that the petitioner had notice of the order which was proposed to be passed on 7/9/2013 at 23, and yet pray for adjournment, the same was done at the risk of the petitioner, and therefore the said order does not call for any interference of this court. Accordingly, this application stands dismissed. I'll take a break and come back. Respondent has appeared. Just a moment, just a moment. Second file. Part file, second file. Okay, you are seeking transfer from where to where? To Sonitpur. What are you doing? Page? Page 15. Okay. Heard. Mr. P.J. Saikia, counsel for the petitioner. None appears on call for the respondent. Next, the petitioner, who's the estranged wife of the respondent, is seeking transfer of the matrimonial dispute, matrimonial proceedings of FC Civil Case number 169 of 2023 from the Court of Learned Principal Judge, Family Court number 2, Kamrup Metro, Guwahati, to the Court of Learned District Judge, Sonitpur. Next, the learned counsel for the petitioner has referred to the statement made by the respondent husband in paragraph 10 of the application for restitution of conjugal rights. That the respondent had been transferred and posted at Tejpur, Sonitpur. And since 16/12/2022, he has joined the duty and continuing to be posted there since then. Accordingly, it is submitted that although the respondent is doing duty in the in Tejpur, in the district of Sonitpur, the proceedings for restitution of conjugal rights was filed at Guwahati. First off, it is submitted that the respondent, who is not employed, is a resident of what did I say? Oh, no. the petitioner is not employed, is a resident of Sirajuli, Sirajuli, Pathar, in the district of under Dekajiri police station in the district of Sonitpur, and accordingly it is submitted that it would be very inconvenient for her to participate in the proceedings before the court at Guwahati. Full stop. Next para. I have noted that that all the process was served on the respondent and he had not appeared. Full stop. The reasons assigned by the petitioner as referred hearing before is found to be just and sufficient cause for the petitioner to seek transfer of the matrimonial proceedings from Guwahati to Tejpur. Accordingly, this application for transfer, which is filed under Section 24 CBC, stands allowed. The proceedings of FC Civil number 169 of 2023, filed under Section 9 of the Hindu Marriage Act, stands transferred from the Court of Learned Principal Judge, Family Court number 2, Kamru Metro, Guwahati, to the Court of Learned District Judge, Sonitpur, Tejpur. Next, the petitioner shall produce a certified copy of the order before the Learned Principal Judge, Family Court number 2, Kamru Metro, Guwahati, to bring the order to the notice of the said Learned Court. So on receipt of the said order, the Learned Principal Judge, Family Court number 2, Kamru Metro, Guwahati, shall fix a date for the parties to appear before the Court of Learned District Judge, Sonitpur, Tejpur, and have the order seen by the Learned Counsel for the respondent husband within bracket petitioner in the said trial court proceedings, bracket closed. Next para, on the date fixed by the Learned District Judge, Principal Judge, Family Court number 2, Kamru Metro, Guwahati, for appearance before the Learned District Judge, Sonitpur, Tejpur, the petitioner shall appear before the petitioner herein shall appear before the transferee court and wait for instructions and await further orders of the said court. Next. What's the next?
Item 6, the method of this DCO.
Hmm.
Again, I don't know the same thing, use you going advocate done, to be respondent to a
Kon?
DCO to be taken place. It might be parting 6.
I think lage apne
देरी के मतलब
हाँ।
दिन लगी
This is that rent suit.
In this case, under the wrong impression that Assam Tenancy Act 2021 that has come into force, the orders have been passed.
Yes.
Sir, your lordship may say this, both your courts are ordered and let the matter be.
By the same court. No, no, I am trying to, I am asking the Learned Senior Government Advocate to come.
Yes.
Because I need that information. He is aware of it. This Assam Tenancy Act has been notified.
But the appointed.
No, no. And there was a move by the state government to open up rent courts. What has happened, I don't know. It's not been notified,
Appointed day has not been notified, madam. That is.
is it?
Yes.
Okay.
I have applied for IPA medal to build information, whether they get enforced or not. I have in record with this, the concern from the IPA.
Page.
63. 63.
63 of my condition.
63.
Yes.
Okay, then I sent it back. I was waiting for only this clarification. Okay. Heard. Mr. P.V. Das, learned counsel for the petitioner, and Mr. D. Chaudhary, learned counsel for the respondent. Full stop. By filing this application under section 115 CPC, the petitioner has assailed the order dated 29/8/2023, passed by the Learned Civil Judge Nalbari in Miss Appeal number 1 of 2023, by which the order dated 3/1/2023, passed by the Learned Munsif number 1 Nalbari, within bracket now, Civil Judge within bracket Junior Division number 1 Nalbari, bracket closed, in TS number 155 of 2021. Full stop. The Learned Trial Court had returned the plaint of the petitioner for eviction of the respondent. And the plaint was returned on the ground that Assam Tenancy Act, which year?
21.
200?
2021.
2021. Has been enacted. And that the civil court had no jurisdiction to try the suit. Under section 40 of the said Assam Tenancy Act 2021. Full stop. Next paragraph. The Learned Counsel for the petitioner has submitted that both the Learned Trial Court and the First Appellate Court had committed grave error in returning in passing the order of return of plaint and affirming the said order by the First Appellate Court. So it is submitted that the petitioner had sought for a RTA reply from the Department of Housing and Urban Affairs and the SPIO and Deputy Secretary to the Government of Assam, Housing and Department of Housing and Urban Affairs has given a reply that the Assam Tenancy Act has not yet been enforced in the state. And the said act has not come into force in any part of the state. Full stop. Next para. On a query of the court based on the RTA reply, the Learned Counsel for the respondent does not dispute that the Assam Tenancy Act 2021 has not come into force, has not been notified and is not in force in the state of Assam. Next para. In view of the said legal position, as on today, where the Assam Tenancy Act has not yet been notified and enforced in the state of Assam, the court is inclined to hold that the learned first appellate court had committed jurisdictional error in dismissing the appeal by appellate order 3/1/2023 in miss appeal number 1 of 2023. And similarly, the learned civil judge within bracket junior division, bracket was number 1, Nalbari, within bracket earlier Munsif number 1, Nalbari, bracket closed, had also committed jurisdictional error in returning the plaint of TS number 155 of 2021 to the petitioner plaintiff. Without taking into consideration that the Assam Tenancy Act has not been notified and the same is not come into force in any part of the state. So accordingly, at this revision stands allowed at the motion stage without issuance of notice on the respondent.
I'll give you the.
No, I'm recording that. The recording respondent. After hearing the learned counsel for the respondent who has entered appearance by filing a caveat. Next para, as both parties are represented before this court, both sides are directed to appear before the court of learned civil judge in the bracket junior division, bracket was number 1, Nalbari, on suggested date after vacation.
Fourth of December.
4th of December, okay. On 4. No, that will be too long. November first week or second week, we can send you.
7.
7th, okay, 7/11/2023. And by producing a certified copy of the order, await for further instructions of the said learned court. So you want an order, then we issue a notice and give you an interim order. And what we will do with the interim order?
That part I have no research in my other.
Pardon me?
Because the respondent is not trying to declare making.
No, then you'll have to, you see, then, no. For that, we can suggest you something. It would be interesting. You'll have to file a leave application for impeding APDCL in this revision. We'll issue them a notice and then they will appear to show us as to why they should not be impeded. No, I understand. But you think of how I can do in a revision where the APDCL is not a party, you expect an order from me. No, it's okay. Then we recall the other order. No. But what I can do is that I can recall my order, issue a notice, also issue a notice as to why the APDCL should not be impeded. For that, you'll have to file an IA. File an IA to impede APDCL. I'll issue them a notice to appear in the matter and then issue notice on your injunction application as to why they should not be restrained from disconnecting electricity. No, but I must go. You see, if you just think that this, I'm a railway engine. I have to only go in a track. There's a prescribed track where I can go. See, if I follow the track, I can give you the relief. I'm not saying that I don't have the power, but I must reach the station. Then only the train can stop. Correct. So I told you I would give you an interesting solution.
I have to close this.
I closed in your other password.
Item 9.
You want to pray for time. But you are always praying for time. Last time also you prayed for time. Today different ground. So we give you, we exhaust your order 1701. We say that on the next date also you will be granted adjournment. So order 1701 complied with. So we give a date tomorrow, sorry, on Wednesday. In Wednesday also we will grant you an adjournment. So order 1701 complied with. No, it goes after vacation now because we can't do anything. No. You know the board on the prayer made by and council of the appellant list after immediately after the ensuing vacation.
Item 10.
Yes. For the time being, okay. Okay, after some time. Yes, 11. Yes. What I for what? Oh, it's available here. No, maybe. Yes, what is your case? Page 70. Just a moment, give me 2 minutes. Yes. Yes. What is the nature of your prayer before the trial court? Injunction, where is the prayer for injunction? Page? Page? Page 26, okay. Yes, what do you have to say? What is the illegality in the order?
That is in dispute. So the appeal and the correctly violation of both the parties, the respondent will found a claim. They also pray for the eviction, my eviction permission.
Okay,
So on the basis of condition of the advocate in court, the London court has found that the opposite party will be the dependent information. So he has cultivated the land. And because of that, he will suffer irreparable loss and injury. That's the problem with competition. But in this case, yes, I am the genuine purchaser of that land and I am in a position as per the commission report. As per the commission, I am in the position till July 2022. Then from the 22, he took the position. That is the case. So in this case, at least my fear is because he has cultivated. So he should get the opportunity of getting the pay from the Supreme after harvesting. The field harvesting, he may be in the position of the because he has already cultivated. But after that, after that he allowed, then there is a chance of transferring the position. At this stage, transferring the position to the third party. Because he has not done, as per my information, he has not cultivated the land. He has given the other party. So the other party will go for the cultivation again, then again. So yes, I am the genuine purchaser of the land and till as per the report till July 2022, I am in position, in the position. So I will suffer into loss immediately. So the balance of convenience. Feel the harvesting balance of convenience and irreparable loss and injury is in favor of the different. Feel the harvesting. But after that, if this continues, like, if there is no any injection, then I will suffer irreparable loss.
What does Order 39 Rule 1 say? What is the language of Order 39 Rule 1?
Protection I need you. One, not to transfer to any other one. Even transfer. And other is after harvesting, I should get the chance.
Where in any suit it is proved by affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or that the person threatens or intends to remove or dispose of the property with a view to defrauding his creditors, that the defendant threatens to dispose the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit. All the three conditions are not there in your case. You say that now they are harvesting. Tomorrow they may give it to some third party.
Yes.
So it is only probability. It's only hypothetical situation.
Yes, recently, today I got the information. About the information, if you also need that, I said file everything or application.
No, your affidavits can't improve. Can affidavits improve the pleaded case of the parties?
Here it is a written fact that I am in position till 2022.
Oh, ultimately, no. You have read your, no, you have read the plaint. Read the prayer in the plaint. Read the prayer in your plaint.
But in this case, you also the prayer, the counterclaim is also eviction. So
No. First of all, we see the case of the plaintiff. I'll come to defendant later on. If I issue notice to the respondent, then I'll.
in this case also, it is written that till July, I am in position.
No, whatever be it, but today somebody else is there. By way of an injunction, I can't prevent anybody from being there, even if he's a trespasser. So all the three conditions are not there. We'll be dismissing this appeal.
There is time. Sometimes, because I have to file the affidavit.
No, you see, whatever you see, by affidavit, what you will do? You will incorporate some statement. We are accepting that statement right here.
Statement with some other.
No, you can't improve your suit. You can't amend your suit like that in appeal. In first appeal, you can't file an affidavit and then change it.
Then if they transfer during the pendency, what will be the effect? Pendency. of
No.
the suit. Because if your lordship dismiss this.
I'm yet to come into, my experience is not vast as Mr. Das here. I'm half his age, so half experience. You see, a person who is not having a title, can he transfer within the meaning of section 52 of the 52A of the transfer?
There may be other party they come to into the position.
He'll be bound by the decree. How you are aggrieved? If somebody comes without a title, he is bound by lis pendens.
There may be question of development.
Oh, that we'll see when it comes. I'm not the trial court. I am the first appellate court. I am to examine whether the trial court order is right or wrong. The refusal injunction is right. I'll pass orders at 2. Whatever statement you want, we'll take it on board right now. Yes,
Lordship, if you are indulgence, I am mentioning action number 25 and 26, my lord.
25, 26. Who is for the other side?
They should be, they both have good matters may be taken up after vacation, my lord.
25, 26. Okay, in this RSA, there is something.
No, second, I actually wrongly directed my matter after being listed for admission hearing, my lord. Why-
That's why. You want to do it some other day.
Let it be
Okay.
after vacation, my lord.
Okay. Just remind us on that day to take up this under order 43, 41 to 11.
Right.
That's why this was marked by me. Okay. 25, 26. Both sides are duly represented. On the prayer made by Mr. NC Das and Senior Counsel, assisted to Mr. A. Das, counsel for the appellant, lists the matter after vacation, after ensuing vacation. Mr. Das, if it's not listed, you make a mention,
No, my lord.
because after vacation, we can't give a fixed date right now.
Right.
Make a mention after that.
Published.
Before writing of this court, because that is already the applicant has making the report officer order. So they are going to take the pressure of the company.
Please repeat again what you are saying. You check for the other side if the other side respondent is there. Then we'll take it up before rising. Okay.
Item 12.
Just a moment. Just a moment. Okay, heard Miss P. Adhikari, learned counsel for the appellant. Next for this. Appeal under section 23 of the Railway Claims Tribunal Act 1987 against the judgment for page 1. That's one, so. Yes. It is. Admitted for hearing by issuing rule returnable in 4 weeks. Let the LCR be called for. The appellant shall take steps, appellants shall take steps for service of notice on the respondent by serving a copy of this order as well as steps on the learned DSGI. List after 4 weeks.
Supply item 54 for admission.
Not there. We wait for some time.
Daily list item 13.
Yes. You file it? Okay. You have to say something more because there is a change of surname. In your bail application, you are writing son of late Sitaram Sen. In the Jamabandi, the name of the wife is shown as Sitaram Nai. Srimati Gita Devi Nai, Swami Sitaram Nai. Entry number 29. Jamabandi you have given us. And the Jamabandi entry number 29 is Sitaram, husband name is Sitaram Nai. In your application, the name, father's name is Sitaram Sen. We'll take it up next week. You get instructions. We'll take it up next week. Get instructions. If the name doesn't match, question of acceptance of bail.
Up to that status report will call for it. What I have found for the status report, it is up to 82,000 BGP. Because the case is still in the computer still.
Pardon me?
Case is still in the computer still.
No, I understand. You see, that is the reason why we are taking up this bail matter. We had rejected it twice. But if for more than 2 years, 3 years, almost 3 years, if the trial is not proceeding, then,
Due to my lord, on the appearance of the one accused.
no, I understand. It may be one accused, it may be 10 accused. But you'll have to expedite the process against them. Now you know the directions of the Supreme Court. We can't perpetually keep this man behind the bars. Even if it's the even if there are evidence that he has shot dead a man. But if you don't commence the trial, then we'll be bound to release him, despite your objection and the objection of Mr. F.K. Ahmed.
So far as document is concerned, he being the owner of the said document, is submitted application to the concerned authority seeking self permission. Seeking self permission, guitar already there. And the self permission is other process, I NOC number, NOC of the 36 of this 19987 of the 2022. This is the one application. That is final this year, 43. On 43, 2022.
At that point of time, they wanted to tell us lot of them. Their family is a very large family. And now they have postponed and
That will not do. Reference NOC has already been obtained.
they had applied for NLC. No NLC was procured. And there is no plan to sell the paper.
No, that won't do when this application is there on record.
I'm also mentioning my original objection on.
Okay, it's a good ground.
The figure is concerned, my lord, that case is already committed against the same accused person. The session, the case has been registered as session case number 53 of 2023.
53 or 23?
Again,
Before the court number,
session code. That's something.
Hojai Shankar Dev Nagar. Okay. Mr. A.K. Sharma, learned counsel for the petitioner, has produced, has filed an affidavit of the mother of the petitioner, who is ready and willing to, who owns landed property and is ready and willing to take bail for the petitioner's son. On a perusal of the documents appended to the said affidavit, it appears that in the Jamabandi, the name of the name of the person whose name portion of the Pata land is mutated is shown as no. Gita Devi Nai, Srimati Gita Devi Nai, within bracket, husband late Sitaram Nai. So in the bail application, the name of the father is reflected as Sitaram Sen. Full stop. Therefore, the learned counsel for the petitioner prays for some time to enable him to obtain instructions. So prayer is allowed. Next para. Mr. F.K. Ahmed, counsel for the informant, has submitted that as per his information, the as against the petitioner, the committal proceedings has been completed, and the offense is to be tried by the Sessions Court in Sessions case number.
T1 53 of 2023.
Pardon me.
Capital T1.
Capital T dash 1
53 of 2023.
53
Yes.
of 2023. Before the Court of Learned Sessions Judge,
That's
Hojai Shankar Dev Nagar. First of all, He has also produced a copy of information downloaded from Seva Setu, SCWA, comma, citizen-centric service provided by the government of Assam. Which application status can be tracked. First off, it is submitted that on 4/3/2023, comma, Geeta Devi Nai has applied for sale permission of the land which is offered as for taking bail in this in the affidavit filed by her. On 13/10/2023. So, please give a copy to him because you have a copy. Oh, okay. The learned counsel for the petitioner shall provide a copy of the said printout to the learned counsel for the petitioner and provide a copy thereof to the court master to be retained on record. Give it also to Mr. As well as Mr. Harjay Barwa, learned APP, has and also provide a copy thereof to the court master to be retained on record. Next para. The Mr. Harjay Barwa and APP submits the present status report of sessions case number T1 53 of 2013 we called for. So according to the registry shall send an email to the Court of Learned District Judge Shankardev Nagar, Hojai, for providing the present status of the proceedings of sessions case number capital T1 53 of 2023. Post of the Learned Sessions Court shall send the information through email for being placed before the court. Next para list on, we are fixing it on Wednesday. 15/11. Fifteen 11.
11 or 10.
Oh, sorry, 15/10. No, 18/10. 18/10. I'm looking at a long month. That's fine. এইটো কাগজ কৰি পেলাই ঠিক কৰাই দিয়ক বিল ওপৰত চাব লাগে বাকী কাগজ তলত আহিব চিৰিলি
পিটিশন খন
পিটিশন ওপৰত ইয়াতে এফিডেভিট ওপৰত আহি গৈছে
ঠিক পাম
okay because whatever you say whatever be the good ground but 800 days before the trial today he's there, tomorrow you may be here some reason.
Daily list item 14.
Yes. Okay.
Hello, they have forwarded the case diary, lots of forwarding report dated 2/10/2023. But the case diary is not up to date. The case diary is up to 12 of August 2023.
This shows that please pass on. But look at this statement here, we are entitled to bail, I think. This,
There are some 164 segments. 160.
no, this is 161.
That I have read. This is the point.
The co-accuser giving name of some other persons, not the petitioner. Huh?
Other question is whether his custody will be required or not. Otherwise,
But if the witnesses are not naming him,
164 versus they have him, but although they are contradictory, one says Muslim, he has something, another says all are something. But anyway, I'm not relying at this stage.
no, but here it's son and the daughter-in-law who are naming their own father or having assaulted. Well, give the CD, I'll just check up against and I'll pass orders. It will be declared on Tuesday. List on Tuesday for delivery of orders. Just write, Mr.
Tuesday.
Huh?
Tuesday.
Tuesday for delivery of orders. But both sides are represented. Just write the name, Mr. P. Mahanta for the petitioner and Mr. R.J. Das for the AP for the state representative. That has been heard. List on so for delivery of orders after perusal of the case diary.
Time being, I think 54 can.
Yes, 54. Yes. Yes, we refused long adjournment because of the young age of the youngest. In fact, on that day, we were having a meeting of all the honorable judges of this court in a particular program. And I said about this sweet submission, about the age of the youngest of the plaintiff, and everybody was was amused by the reference to the age and the polite submission about the age. I understand. Yes, yes. Just a moment. Where is the copy of the plaint? You're for the you're for the defendants. Your application under order 7 to 11 was rejected. Yes. Page 66. Yes. Yes. Page 80. No, but you see, even if you say that under the Dyabhaga law of succession, the property would go to the eldest male. But once he dies, the legatives have a right. You are saying it doesn't have a retrospective effect.
principle of the fee, but if minor comes to section 4, of the act, section 4 goes against the fee. One for I have to make a change of so why are the effects of the act? Even when otherwise expenses provided in this act, any can remove all interpretation of Hindu law or any custom or procedure as part of that law. Therefore, immediately before commencing of this act, and please to have effect with respect to any measure for which provision is made to this act. Especially, my lord, I cannot hesitate because of this. Because of the bar created by the under section 4, because in the engine order, let us say that is the mechanism. Ultimately, kindly come into the prayer person made in the place. Ultimately, kindly come to this assume what they are exactly doing.
Title interest, pre-declaration of settlement of shares and partition. Hmm. $35. Yes.
Second, also minus the 4% benefit. The plot of land measuring 1 giga 17 acres. Then minus 5. The plot of land measuring 16 giga 16 and half acres at longer mode, longer ability. This doesn't fall within the territory.
No, but there is only one partition suit. There can't be a multiple partition suit. Supposing maybe I always give examples which are very horrible, but only examples. You see, knowing your what you call demeanor, attitude, aptitude in the court, legal acumen, we find you to be a very, very successful lawyer 3 or 5 years down the lane. Correct. So you have a property in every state in the country. But assuming that your brother sitting next to you, he claims that in the courtroom, today 13th, he called me brother, and therefore I have a share in that property and files a partition suit. There will be only one partition suit, although you have a property at all the states in the country. Yes, yes. 16. Yes.
Party number 4 then minus party number 5, which is a zero. So party number 6, which is opposite to 5. So therefore, the properties of serial number 3, 4, and 5 do not fall within the territorial jurisdiction of the now, in a partition, what is the position of section 60? So, in a kind of section 16 of
16 of? Oh. When a property is situated outside the jurisdiction.
to be instituted where subject to the significant and other limitations prescribed by any law. For recovery of invisible property which was without range of opportunity, it is primary. B. For partition of invisible property. Down below also 25 can be instituted in the court within within the local limits of this jurisdiction, the property is secured. There is a provision provided that a suit to obtain relief respecting or compensation for wrongful immovable property held by or on behalf of the defendant may, with the relief what can be temporarily obtained for his personal obligation, be instituted either in the court within the local limits of this jurisdiction, the property is secured, or in the court within the local limits of this jurisdiction, the defendant expressly and voluntarily respect and carries on complaint of personally was for him. Wherever the defendant admittedly or residential visual. Number one. And number two, difficult to basically it is a suit for participants. It is not a suit to obtain any relief or compensation for wrong done to any individual. There is no specific prayer made in the case. So therefore, my acceptance submission at this stage is where there is a bar created under section 16. Minus subclause B of CPE. Which describes the definite mode and manner in which by which manner this suit has to be instituted. If that suit is however particular immovable. And the parameter that is kept therein is manner that falls within whose local limits of whose jurisdiction the property is situated.
Yeah, it is one Partition Act,
That
P. I'm searching for a case Dhula Bhai. Got it. Yes, Mr. Dekha.
Sure.
You have to entertain this application. The suit has to be stayed.
I'm covered by section 17. Covered by section 17.
17. The 17 is not applicable here in your case.
17 is applicable.
How?
Lord, there was some controversy whether the word proper 17 would apply only to a case where the property is a huge property which is spread over districts, or will it also apply when there are properties involved?
No, 17 is where the suit is to obtain relief respecting
Yes,
or compensation for doing wrong to.
respecting.
Okay, so you say respecting or remote party will also come there.
Yes.
Okay. So then what happened in that?
Now, my lord, the Supreme Court was encountered with an argument that 17 would apply only if the property is a huge parcel of land and it is spread over 2 or 3 districts. Then the Supreme Court relied on the General Clauses Act, and it held that it would also apply for property, as in 2, 3 distinct properties if they are involved. Twenty 11 is CC 629. Paragraph
Yeah, just a moment.
Takes up para 9 onward.
This judgment again takes us nowhere. You see, the submission of Mr. Bobzeri is that the present petitioners are not the residents within the jurisdiction of Kota Shivsagar. That is his submission. In the case you have cited, what had happened was 7 and 8 were residents of Indore. And therefore, when this application, the set to defendants applied before the trial court for striking out pleadings and to strike them out as parties, because they were not the residents within the territorial jurisdiction of that case. Supreme Court has discussed the matter, and then it has arrived at a finding that the trial court did not commit any error in striking their pleadings and to strike them off as co-defendants. So although you see, the suit could have been otherwise tried under section 17, that is what the finding is. But ultimately what has been upheld is that striking out of the pleadings and rejection of claims, sorry, striking out their the defendants were 7 and 8.
Here 16B and 17 has been specifically dealt with. What can be deduced from these paragraphs, particularly 11, 12, 13 and 14, is that when 17 says any portion of the property unit, it may not just mean a single property, it can mean and include other properties as well. Now, perhaps there was a property in Bombay and a property at Indore.
Indore.
Now, Lord, relying on 17, it has been held that it could have, because 16B has.
No, it could have, but still the striking out of the pleadings and the ring of parties has been upheld.
But that this is, our case is concerning jurisdiction alone. First of all, of course, under 711, they cannot raise jurisdiction alone. At best, it could have been an application under 710. Now, what we are on is, their plea is that since there
No,
are.
if the application succeeds, then it can fall within the meaning of 7 order 7 to 11D, barred by any law.
It is at best a question of territorial jurisdiction. And Lord, what I'm on is, section 16 doesn't concern residents of the parties at all. 16 is concerned only with the property in question. Now, so it says that under 16.
No, 17 also does not,
No, 17 also does. 17 also does.
but yet you look at the finding. It is upheld. What is available? You see the ratio would be what?
Ratio is going to read those
Uh-huh.
paragraphs. Lord, first, your lordship will take up para 10. Para 10, section 17 is reproduced, so your lordship can continue from 11. If I may read, Lord. We need to notice the scheme under the Code of Civil Procedure as delineated by section 16 and 17. Section 16 provides that the suit shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Section 16B mentions for the partition of immovable properties. Now we look into section 17, which deals with suits for immovable property situated within jurisdiction of different courts. As per section 17, the suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situated. What is the meaning of the words any portion of the property? There may be a fact situation where immovable property is a big chunk of land which falls into territorial jurisdiction of two courts, in which fact situation in court in whose jurisdiction any portion of the property is situated can entertain the suit. Whether section 17 applies only when a composite property spread in jurisdiction of two courts, or section 17 contemplate any wider situation. One of the submissions of the learned counsel for the appellant is that the word property as occurring in section 17 shall include the plural as per section 13 of the General Clauses Act. Section 13 of the General Clauses Act provides as In all central acts and regulations, unless there is anything repugnant in the subject or context, one, words importing masculine gender shall be taken to include females, and words in the singular shall include the plural and vice versa. Applying section 13 of the General Clauses Act, the Bombay High Court explaining the word property used in section 17 held that it includes properties. We are also of the same view that the word property used in section 17 can be more than one property or properties. The word property under section 17 of the Civil Procedure Code may also be properties. Hence, in a schedule of claim, more than one property can be included. Section 17 can be applied in event there are several properties, one or more of which may be located at different jurisdictions of court. The word portion of the property occurring in section 17 have to be understood in the context of more than one property also, meaning thereby one property out of a lot of several properties can be treated as portion of the property as occurring in section 17. Thus, interpretation of the words portion of the property cannot only be understood in a limited sense and restrictive sense of being portion of one property situated in jurisdiction of two courts.
Yes, yes.
Now, my lord, other judgments will also discuss, and ultimately it was held that section 17 applies to such a case, and therefore it can be instituted in any of the districts where even one among that lot of several properties is situated. Now, my lord, here it was not just concerning jurisdiction, my lord. There was a joinder of causes of action, which is why eventually perhaps it was held that some a few of the pleadings should be struck off. But insofar as section 17 is concerned, that was decided to mean that it could be instituted in any of the districts or the jurisdictional courts. So, Lord, I cannot be expected to file now 3-4 partition suits, because in any case that will again defy the other principle that it should all property should be included in the hotspot, my lord, and there should not be suit for partial partition. Now, if I sue for the Sipsagar properties at Hibohagar, and then again I institute another 2 suits, 3 suits, one at Shillong, one at Nazira, and one at Lanka.
Dream of Bharat Bhavan will be fulfilled.
Which is why, you know, I believe section 17 is there to for a situation like this, you know, because admittedly I can include more than one properties in a single suit.
What did the trial court say?
Page 18.
Now, when considering the question of rejection of claim, we have to confine ourselves to the appliance and claim, where beginning the claim itself. In the case of going to the previous bench of the Supreme Court itself, that the conclusion as to rejection of claim must be drawn from the environment creating the case. The bench observed this will clause three of order seven, and the environment is in the place. And this purpose, there cannot be resistance or obstruction. Then I was saying 87, in conclusion, it can be said that unless the plane is stable or perspective and improper, the plane cannot be rejected. And the ground which the citizens have laid with the citizens do not find the change on such required ground.
Just to point out, in fact, in para 54, the principles have been laid down of that dam.
This issue of 16 and 17 was never touched by the trial court. It was not placed there. No, you see, there's another interpretation. You'll find bracketing commas in grammar. Bracketing commas. You see, here the language is where a suit is to obtain relief respecting, comma, or compensation for wrong to, comma. So this appears to be a bracketing comma. Now, if you artificially put a bracket there, then it will be when a suit is to obtain relief respecting immovable property.
Right.
So it becomes a bracketing comma.
But what large scale manure is able to use the particle. Even in section 62 to be executed. Subject to declare or other units affected by any of the what the position of A, B, C, D, definite manner situation has been enumerated there. What sort of beliefs are to be of manner from the position? If it is a fit for position of individual properties, shall be instituted, it is mandatory. Shall be instituted in the code within the legal limits of this jurisdiction the property situated. This cost may matter. When we come to the provision, when we see the provision has been constructed. Provided there is need to obtain relief, respecting all compensation for wrong use, removal property, well, but or on behalf of the defendant, may whether relief. This is almost similar to the language in section 70. So, article is considered as my system, article is considered as a different aspect of the matter, and then we are down putting relief or long down to individual property. I say, when a bigger this compensation may be managed, then it will come within the ambit of section 70. I can craft defined property declared within defined territorial jurisdiction, but not in the partition. So therefore, I have drawn minor attention to the release of in the.
Okay. Will take me some time. I not undecided. District on Wednesday for delivery orders. When Mr. Albert Pujari, when it comes to the petitioner. What is this case cited? What's that? No, complete your part, because otherwise if I'm closing for orders, you'll lose that opportunity. It is just because this list has been pasted here, I could come to know that citations. Just one, that's.
Kindly come to page 29. There are 14 minutes. As it says in the page, there is a problem. This is a dealing with the release of property.
Yes.
The property which has grown upon the years of late benefits of Kalina, the plaintiffs are equally entitled to shares in respect of the said property. Document kindly mark this well. The partnership business of Solomonic TSA is also a partnership business between the heirs of late benefits of Kalina and Jumana. The plaintiffs are equally entitled to the right in respect to the business of Solomonic TSA as well as Solomonic TSA itself is the extent of 50% of the face detail and the tea estate along with the other debt position. The plaintiff was further entitled to the shares of Donamoli tea estate as a creditor. Equally, with yes, Odisha and their mother, yes, Trinity Collection. Under such circumstances, the plaintiff seeks for a declaration of the right in respect to the property in Schedule G, the Donamoli tea estate, the business of Donamoli tea estate, as well as the shareholders of Donamoli tea estate continuity. The plaintiff further seeks for partition of the tea property described in Schedule G, the business of Donamoli tea estate, shares, etc. As some of the property described in Schedule G are accessible to review, the plaintiff seeks for a preliminary decree of declaring their rights and thereupon directing the collector in terms of part of the estimate with the means and bounds. But they claim that they are to be delegated to the position of a collector. However, this is permissible in view of section 4 of the Companies Act. Further, we shall obtain a only from another paragraph 12 of the CBC.
It does not include inheritance. Companies Act does not does not include inheritance. The Companies Act. You see, a company law tribunal does not have jurisdiction to decide the inheritance. So if supposing X claims that his father died leaving shares, so therefore instead of A, B should get it. If that is the suit, company tribunal will not have no jurisdiction. No, but you see, the tribunal will only have jurisdiction, you know the jurisdiction, limited to no, it's a limited company, so it will be only share. No, for that, the plaint cannot be rejected. There's a unique situation for a tea garden. In the tea garden, the company holds there's a company formed, correct? But because of the grants which for which land has been allotted to them, the business is run in the name of a tea estate. It is the tea estate which is being held by the company. Now this fiction of T state. Constitution will not know otherwise. What is the T state? No, there could be a case for striking or pleading if you can, under order 16 rule 6. But it can't be a ground for rejection of plaint. No, you see, but that is something which can't be decided at this stage. Let us say a plaintiff comes and says that this land A belongs to me. Correct. And you have a good reason saying that this A itself is a disputed, it's a, let us say the part of the A land is a judge's field. You have a good reason for saying that. Now, can the plaint be rejected on that ground, that a prayer is not tenable? It can be a case for rejection of plaint, sorry, striking out of pleadings or the prayer. But to reject the plaint on that ground, you have to convince me more. What is that advertisement? Dil mange more. No, because that, you see, that may be a good argument for any other purpose, but not for the purpose of rejection of plaint. The court will not grant it. If the court finds that this is a prayer which is otherwise not tenable, the court will not grant it. There are several reliefs claimed. Court may give one, may not give one another. But for rejection of plaint, this I don't find it's a convincing argument. One is this 1616. That is good. Second one you have made with regard to the third one. Can I give a test to it? Let us see that. You see, what happens is that it's just to tell you that there may be another way of interpreting it. Now, if A, who is the plaintiff, becomes entitled to a share. So, being a sharer, he can ask for rendition of accounts. Under the Hindu law, he can do it. Number two, if he succeeds in showing that the property which is for which partition has been sought for is being held by X on my behalf also. So he becomes an agent, and then again as an agent he becomes entitled to disclose the rendition of accounts. So perhaps those arguments that's but you have taken a point. That's why I say I can give it a twist. Pardon me? Yes, you're right. And those citations you were citing, please give that, otherwise I won't remember. Something, no. You have given a slip, but this slip will not register in my mind unless you say something. $77 for a CC. What does it say? This clever drafting is repeated in several judgments thereafter. Okay. Court can pierce the veil and see what is really intended. Okay. Para. .11. Just a moment. Yes.
Otherwise would not be maintainable or barred by law. So what is the law would not be maintainable or barred to be proceeded by the bar also will not be maintainable. It has been consistently held by the court that is never doctrine of the plaintiff was created the illusion of the cause of action. The court will repeat in the past that the earlier so that the law criticism will end at that final stage. Other thing is the Jessica of 1977.
Okay. This one, what is it for delivery orders? So there goes my tomorrow.
Third is 16th on Wednesday. On Wednesday.
What is it for delivery orders? I have not yet made up my mind.
I'll advance a few arguments on that.
Hmm?
I'll just address the issues.
Ah, yes, yes. Please,
Well,
sleep.
Wednesday, you'll
Slip.
take it up Wednesday.
No, no, you will do it because on Wednesday we will not be hearing you.
Lord, coming back to that issue of section 17. Lord, I'll again take your lordship to that judgment, Lord, but before that, Lord, section 16 and 17 is held to be part of the same statutory scheme. Lord.
That we have seen, it's mentioned there.
Yes. And the principles have been culled out at paragraph 35, Lord, where they have categorically said that's because this was a suit concerning 16B. And if it said that 16 and 17 are part of the same statutory scheme, therefore 17 would also apply insofar as 16B suits are concerned. So therefore, the proviso is on a different footing altogether so far as the proviso to section 16 is concerned. If I have understood it correctly, my lord, the proviso only said that if it is in respect of an immovable property and the relief sought can be obtained without the personal obedience of the defendant, then there's an option where the court within whose local jurisdiction the defendant resides, there also a suit can be instituted. So proviso, in my respectful understanding, has no application insofar as this suit is concerned. Now, insofar as 17 is concerned, my lord, first of all, when it says, like it has been, like already your lordship has observed, respecting would mean anything in respect of immovable property. Which is why Shiv Narayan's case also, they've referred to 17 and 16B together. They've conjointly read it and said that it's part of the same statutory scheme. Now, Lord, so far as the other issue is concerned, there my learned friend has urged that this is a matter which should be ideally tried by the company, NCLT or the company law tribunal. Now, Lord, if your lordship reads the plaint in a methodical manner, your lordship finds our cases that there is one common corpus of the joint family funds. From that corpus, business was being run first as a partnership firm, and then a company was also registered. But in essence, it always remained the joint family business with 50% earmarked for one lineage, for one family and another 50% for another. So merely because firms have been registered or companies have been registered, it would not partake the nature of an independent property so long as I can prove during the course of trial that all of it has originated from the joint fund of the family. So that is of course a matter of trial which I'll have to.
Go back to Solomon and Solomon.
Yes.
Once the property is vested, that's a decision which says that once the property is vested in a company, then it's no longer that individual property. And that is why that Solomon decision.
But here again, my lord, ultimately it was being.
You
run-
can't go back.
Lord,
You can't go back. How many years old is this company?
it is old, my lord. The suit has
So-
been instituted just recently.
So if you want to
Now,
take out a,
99.
if you want to take out a property of the company, is the company a party here?
Company is not party, my lord.
Then-
What I'm trying to,
No, you see, it's a simple question I'm asking. I was referring to Solomon. And then I'm saying whether this company is a party, because you are trying to divest the party, the property of the company from it. And you are incorporating that in the family hodgepodge. Once you say that without the company, you have yourself made out a case where interference would be permissible.
No, here I just make two broad arguments. First of all, this application otherwise is under Order 7 Rule 11. Now, merely because one or two reliefs from the plane cannot be granted, the entire plane cannot be rejected. I think that was settled in a judgment and placed it on Wednesday. That is number one.
No Wednesday. If you can't give it today, it's closed.
Manoj,
I don't carry anything in my head.
before the court, right?
I don't carry anything in my head. I go home as a free man, without any dead body in the brain.
Manoj, before the court, right? So, Manoj,
It is only when I open the brief, if I get my note, I can recollect it. But without my note, when I close my note and give it to my court master, I am a free man. I don't carry things home. Except this brief, when I said that my tomorrow is gone, that means this brief is going home today. That's why I'll be working tomorrow, so therefore my tomorrow is gone. Yes.
Basically, even if one or two reliefs, there is some doubt regarding tenability of a relief for one or two.
This is not required because I have myself authored an order in that regard.
And secondly, Manoj, merely because they have formed it in the styled it as a partnership by now. Because company law tribunal, I cannot initiate anything because I'm not a member. Manoj, and secondly, Manoj, even if for a moment assuming that it has changed into a corporate entity, if the roots can be traced to the initial corpus, Manoj, then I can maintain a claim for partition. One judgment in place which may not be squarely applicable, where this sort of issue had come up, where some of the family members said that we are directors of a particular firm, and therefore whatever income has been generated has to be considered to be our individual property. Now, like I said, it may not be directly applicable, but just to, we'll take up paragraph 13 first, 13 and 14. (1986) 1 is 3.
Before I read this, let me ask you a question. You are governed by the Daya law.
Yes.
That means the concept of HUF is not available. Now, if you say that there was a family joint corpus, and some amount was taken away from there, and it was applied for purchasing shares, that is your argument. But if you don't have a HUF, from where do you, where is the root of this argument that there was a joint family corpus?
There are pleadings to that effect.
No. Pleadings don't override the law of the Abhaga law of inheritance. You are creating something which is not available. So therefore, you'll have to show something on the document that it is a family, joint family. There must be something to show that. Merely a statement. Yesterday also I gave an example. My examples are always horrible. But yesterday I gave an example. You see, A is a person. He files a suit saying that he should be declared as a president of India. He produces a copy of an affidavit sworn by him that I am the president of India. And this suit is proceeded with. Now, oral evidence that I am the president of India. 10 people who are his very good friends come to the court and say that yes, we know that he is the president of India. Why? Because every day he says that he is the president of India. So, accepted. Now tell me whether a decree can be passed that A be declared as the president of India and sent to Rashtrapati Bhavan. self-declaration is no declaration at all. So merely if 2 people come and 10 people come, say something, assert something, it doesn't make black white.
But this particular tea estate, the landed property is of our ancestors. Now, for the purpose of running the garden, Manoj, they had,
That won't do good. You see, for a simple reason. Number one, you'll have to show by producing the copy of the memorandum of association, articles of association. How did these the people who had signed the first memorandum devolve the property to the company?
that is again a matter of.
No, not that. But your plea fails here.
Now, Manoj will,
Because you see, there's another aspect to it. The twist I was giving here will come in here now. You see, now let us say there were 3 brothers, originally 3 brothers, correct? These 3 brothers had a joint corpus. That is what you are projecting. Now, out of these people, let us say 1 or 2 died. There are some legal heirs, their representatives, who have now contributed to the shares of the company. Now you'll have to disown that, what you call the first corpus, which is required to be incorporated in the memorandum of association, saying that these people subscribe their hand to become members.
I get what you
So therefore, you are now questioning their source of funds. You have to question not only that, they have to question your their income tax returns, showing that this was their corpus. Then you have to include all those people who are the legal heirs of these people, saying that the corpus which was presented before the court for the purpose of purchasing share should be reverted back. If you say that, then you fail.
But viewed from another angle, my mother was a shareholder. So
Correct.
at least to her
No, no,
shares,
no. You're merely because your mother was a shareholder, you'll show it because of the name, 3 names known. One, we know who is he, correct? Definitely there will be his income tax return. He won't be outside the scope of taxable return, taxable income. If you have a property, you are a tea garden holder. If you have property, landed property at 5 places with a tea garden, none of you are what you call non-income taxpayers. How do you show it to us? Supposing you consider me to be a trial court judge. Now, produce these facts, it's not there in your plaint. Merely by saying, you see, merely by saying that my mother, if I say that my mother contributed X amount of money for property of A, will it make me claimant to that what you call property? Because if that be so, there are hundreds of people who will now come up and say that, well, I am giving a declaration. My father contributed to A, my sister contributed to B, and everybody's property. How much population in the country? Everybody files a suit for property of X, Y, Z, Z. Merely by saying that my father contributed to him. Therefore, I become a shareholder.
So, what I was on, first of all, of course, I think it's regarding corpus and that whether there has been blending or not. Of course, that your lordship is right. It is
No, if you
not-
raise it, because then I'll have to observe. If you don't raise it, I don't observe anything in the order. But if you raise that plea, definitely you will say that it, because I'll have to then return a finding. Your argument can't be allowed to be wasted. So what I'll do is that I'll record in the order and then say that, well, this may call for a what you call rejection of print of the account, but no order 7 rule 11. But I'll have to give some finding. If you press the argument, you get something.
But since my friend has urged it, I have to respond in some. And secondly, we will not have at least entitled to.
What you say is what you get. So don't press it. All these things, don't press it, because if you press it and I note it, then it goes into the order.
I'll
No.
leave it at that.
I should become a non-interactive judge. I would have entered this matter an hour ago. My interaction takes time. I'll try to become introvert.
Item 15.
Place of two jobs.
Of that.
Yes, yeah, the plaintiff for the defendant.
This matter, we have not been served the copy of the RSA.
Not served. You're caveator.
No, the IA was filed, that was condoned.
Oh, you had appeared in IA.
No, this RSA was this is the second time.
No. You appeared in the IA. Then give a copy.
RSA copy would be required.
You guys entered appearance and give a copy. Ah.
Oh, it is there.
Disposed of IA as Okay, Mr. Shiladitya and counsel for the appellant shall provide a copy of the memo appeal to the to Mr. H. Gupta, learned counsel, who has entered appearance for the respondent in the condonation application, which has been already disposed of. First one. List one. It goes after vacation. List after vacation. Date I'm not fixing it. I'll make a mention. Because after vacation we are at a loss of what you call a lot of cases are being shifted after vacation. You can't have a slot right now. Make a mention after that.
Item 16.
No, it goes after vacation because we can't take up matters. Is the second appeal? No, I understand, but next week, there are difficulty. We are very close to vacations. After vacation, you make a mention after that, we'll get a date. Right now, we are not fixing a date. You make a mention, we'll permit on that time. On the prayer made by Mr. Mr. G. Imtiaz, counsel for the appellant matter stands adjourned today. List after ensuing vacation with liberty to the counsel for the petitioner to make a mention.
Item 17.
Okay, there's no representation, just after vacation. It goes after application. You make a mention after that. Your name? R. Ahmed. For the appellant is present. On his prayer, John. Make a mention if it is not listed after vacation.
We have leftover at ASIC and Supremacy list.
Left over.
It refused. It's an item.
Yes, leftover item 5. Just a moment. Just a moment. Yes. How did the trial court deal with the issue of defaulter?
Try to. I could say, I have not paid any.
Where is that? Where is that finding?
It's 32. Era 14.
32. You have a copy of her evidence on affidavit as defendant DW? What are you doing in the suit premises? Huh?
Girls hostel.
Girls hostel. Okay. You have a copy of her evidence cross-examination? You have, Mr. Dhar? Pass it on.
They have not executed it.
Huh?
They have not executed it.
Not exhibited. That Mr. Sahu.
And you're just to that.
No, in an ejectment suit, there may be hundreds of hundreds of unsuccessful suit, and after that, there's a suit which has been won by the landlord. There's no res judicata applicable in page 52. Yes. Just a moment. I've called for this evidence. Yes. Page 52. Yes.
Over you must be. From which particular day, month and year. And I make the statement for that. And how much area. Against the relative by the defendant and against the taking of the plaintiff. That is intended to pay them at the rate of 11%. If the deposit is same in the same account in the same. But to this effect, the plaintiff does not agree to include the tenancy agreement. Going in town and from under whose defendant is required to pay rent. Therefore, it is established that there is in fact no such tenancy agreement between the plaintiff and the defendant. How do they? This is the base. Oh,
Take you anywhere.
so-
Doesn't take you anywhere. That's why I asked for the evidence of DW. In the first para 2, first line is that I used to pay rent. Deposit monthly rent in the bank account of the plaintiff. That's the first line.
They say-
No, once there is an admission, why should we go there? When there is your admission, this could have been, what you call, it could have been decreed an admission.
However, total record of only that item. And how is it? Before, according to finding of report, was there to record the finding of the due date figure? That was not done by that, by both the courts. Which is material fact for deciding whether I am defaulted or not. That was not done.
Just a minute. Mrs. How come to page 22? This is your written statement. First come to page 21. Para 12. First line. Correct. After this first line, come to page 22. Paragraph 14. Last 6 lines where there are corrections. It's your own admission to deposit the bank in the bank account in the month of so and so. I don't, you know, no, Mrs. How you are saying that the due date is not there.
Yeah, so you
Yeah.
can not stick there.
But it's your statement.
It is not disclosed because it is not there. Secondly, what does it say? That if you see yes, then you adjust those amounts against those marks. That is their only. If I have not paid, then we entitled to get that mark. But that doesn't mean that the due date is there. Suppose he has actually.
No, I can understand.
But the due date is not there, court has not recorded any finding without to that effect. And one more aspect is that the earlier suits record was also in that. And in the record of the earlier suit, they have executed two agreements. One agreement with the plaintiff, which one from Tamil Nadu. It was there. And some documents relating to me and the Tamil Nadu. How well they are, it is they are evident. Because under such circumstances, who has to be whether I am a student or under penal, and whether this case has been decided in the absence of the Taluka. Court has not discussed those reports. And otherwise, this yeah, the court has not recorded its finding to what the exact investigation.
Okay. Yes,
My lord has rightly shown paragraph 12 at page 21. My lord. Can you see that the defendant who is a tenant of the plaintiff earlier filed a title suit in the court of Munsif against the plaintiff for relief of permanent injunction against the present plaintiff, not to evict the defendant except with the due process of law. And defendant along with the plaintiff filed a mise for interim injunction in favor of defendant. And the plaintiff contested the suit by filing written statement and made counterclaim against the defendant for eviction, and the said counterclaim plaintiff awarded the present plaintiff is not a tenant of the plaintiff, and she is a subtenant of one Pankaj Talukdar, who was made as defendant number 1 in this one. So then my lord, this suit was dismissed. Now today, does it lie in his mouth, my lord, to say that no, I am not a tenant? What due date, my lord, you yourself got admitted from, my lord, even actually the trial court determined the default from a particular period, which has been corrected by the appellate court. If your lordship kindly comes to page 37, my lord. Page 32 onward on finding of default. If your lordship would kindly come to page 37, para 23, my lord. The plaintiff pays for recovery of rent from the month of January 2015 to December 2017. This suit was filed on 25/1/18. From the materials on record, it is found that the defendant is a defaulter since May so and so. However, limitation is so and so. My lord, then my lord will kindly come to page 53. My lord, my learned friend referred to para 12. He stopped in between. Kindly permit me to read this para 13 at page 32. 52, my lord.
page
Page 52.
52.
Para 30. My learned friend read para 12, my lord, where regarding the date and all was not there, very clear. In this context, it is noteworthy that it is the admitted fact on the part of the plaintiff that the counterclaim filed by her against the defendant appellant so and so entitled suit was dismissed for not having been able to establish the fact that defendant is a subtenant of the plaintiff. Nevertheless, in the present claim, the plaintiff nowhere specifically pleaded that from which particular date the defendant is a tenant under her, but there is a pleading to the effect the defendant is a tenant under her since Luna Kolita instituted the previous suit. The previous suit means title suit number so and so, though the plaintiff did not specifically pleaded the same fact. In this context, it is to be seen whether plaintiff is entitled to radial rent from the defendant since TS number was instituted by Luna Kolita, in which the plaintiff Kiran Gowda filed counterclaim, which was also eventually dismissed by the learned court of Munsif, holding that the plaintiff failed to establish that Luna Kolita is a subtenant, and subsequently plaintiff is not found to entitle to recover the suit premises by evicting Luna Kolita on the ground of being subtenant. Therefore, from the above discussion, it is crystal clear that the plaintiff Kiran Gowda is legally not entitled to claim any rent from the defendant appellant till 12/7/77. 17. Since plaintiff recognized the defendant appellant as a tenant from 12/7/17, therefore, though the plaintiff did not specifically plead this fact in the plain, but from her evidence adduced in the court, particularly in her cross-examination, it can very well be presumed the defendant is a tenant only from 12/7/77, from which the plaintiff recognized her as a tenant. Therefore, logically, the plaintiff is entitled to rent from the defendant with effect from this. The court has gone by the, my lords, evidence of the defendant itself, my lord. In the cross-examination, she clearly admitted, my lord, that she has not paid the rent. So eventually, my lord, court came to the conclusion, the Lord Appellate Court, that the tenancy can be recognized only from 12/7/7. And my lord, it's a concurrent finding of fact, my lord.
But then you'll also produce before me the copy of the
Cross-examination.
PW and the cross examination.
Yes.
You have it or we'll give it some other day? You have it. Yes, this I've seen.
In fact, my lord, the order was of 35/23. And today we are in, my lord, end of October almost. In fact, today was the date fixed for, my lord, final execution. I think what happened.
That is where I have to understand.
From our side, my lord, we can give one concession, my lord. Already, my lord, from 35, 5 months have gone, my lord. Another 1 month. One judgment of our High Court, my lord. This is reported in 2016 6 GLR 255. Paragraph 10, my lord.
2016,
2016 6 GLR 255, para 10, my lord.
what does it say?
Regarding, my lord, scope of interference when there is, my lord, concurrent finding of fact, para 10. In a catena of judgments of the Honorable Supreme Court has held that relationship between landlord and tenant is a finding of fact. A reference to the judgment of the Honorable Supreme Court in so and so would be instructive in this case. It is also an established law that concurrent finding of fact arrived by the learned courts below cannot be interfered with either in a civil revision or a second appeal unless perversity is pleaded and established. And most importantly, in this revision petition, my lord, the ground of perversity is not pleaded. Having gone through the detailed evidence in documents adduced by defendant, particularly Exhibit Co to Exhibit Law, it appears that same plaintiff had tested his fortune in a number of earlier litigation against co-tenant of the present defendant. In all those litigation, it was held that plaintiff so and so is not landlord with respect to the two premises. The present suit is one of the shop room of the premises with respect to which the title suit number was litigated between the parties. Present plaintiffs were the plaintiff in that suit, though tenants were different. Even in that suit, learned court arrived at the finding of plaintiff could not establish his status as a landlord. Even in the present case, apart from his own assertion, the plaintiff could not bring any material whatsoever on record. Its event can remotely show that the plaintiff number one used to collect rent from the defendant and that the rents were paid up to so and so. When defendant raises specific issue, the plaintiff number one does not have any locus standi intention to sue, as the suit premises were managed and maintained by regular trust constituted on the executive job. The plaintiff did not lead any evidence to show that it is he who has been collecting them from the defendant. In absence of any specific evidence in support of the claim of the plaintiff, and more particularly on failure of the present evidence petitioner to show that concurrent finding as to fact of landlord and tenant is perverse, there is no scope of interference with the two judgment including the present petition. Revision petitioner has failed to make out as to how the finding of the learned court below are not based on material record. Learned first appellate court has applied its mind and has independently verified the document, apart from considering the judgment of the learned trial court on the relations. Such a considered opinion arrived at by the learned two court below cannot be interfered with mere insufficiency of the present case. So basically, by law, this is an authority for the proposition that in case of concurrent finding of fact, unless perversity is treated by law, normally your lordships exercising revisional jurisdiction will not interfere. And when as I have submitted, the ground of perversity is no more pleaded in the revision case.
So I have a specific point that before recording finding of before that, four has to go, two has to rather, what is the two there? That is the only one that this is done. Paragraph 9.
Yes,
Paragraph 9.
I've seen that.
It has always had to. It is the foundation.
No, the entire case which has been made out in the petition, revision petition is my lord. That there is no relationship of landlord tenants. That's the case projected in the revision petition. There is nowhere mention about regarding my lord that before determining the, whether one is a defaulter, that the date has to be determined. Those are not pleaded, my lord. Well, learned friend cannot take us by surprise by arguing something which is not even pleaded. There's nothing. All that is pleaded is, my lord, he is not a tenant. There is no landlord-tenant relationship. Whereas in the written statement in paragraph 12 at page 22, he admitted. And my lord, regarding default also he has admitted. So what is there, my lord?
In fact, from the materials available on record, it does not appear that there is a landlord-tenant relationship. It's not there.
It's there.
On
Correct.
paper, it is not
As
there.
rightly held by the lower appellate court.
That is not there. So,
And when he is admitting my lord. In written
their
statement,
admission is again, that's
para
that's
12,
something.
That's very crucial in this case. That's why my lord, no issue was framed. Otherwise, they should have been framed. Once there is an admission, there is no requirement of framing the issue. And my lord, not paying rent, misutilizing the property, running a hostel.
No, but I'm undecided. Okay, I'll think over and pass orders.
Fine.
Today perhaps they will evict you. Today perhaps they will evict you. So we don't-
You'll get an order.
Yes.
Don't worry. Just take time because I have not yet formulated. Once it is undecided,
I think my lord, evidence part would be enough.
I have taken that.
Yes.
Because while you were reading
My
that
lord,
part of the judgment, I was
Lordship
partly
is
reading,
absolutely correct, my lord. At least that part was not established,
Hmm.
but there is an admission.
but there is an admission. That's the only thing.
Yes.
So therefore,
Therefore, issue was not framed, my lord.
no, I get it, but still, it gives me
I know, my
a
lord, we live with your
question.
lordship's matter.
It gives me a question to ponder. Because because you see the evidence came later on. Issues will be framed, will be framed on the basis of pleadings.
Yes, but pleadings was there that he is admitting. In pleadings, my lord, in evidence, sorry, in the WS, there is an admission.
W is there is an admission.
Yes, para 12, page 22.
Oh, para 12, this. Oh,
Yes.
yeah. Huh.
There is admission.
No, I was reading this,
Oh.
this, was
Evidence,
overwriting.
evidence came subsequently.
This, okay, page 22.
Page 22, my lord. Para 12.
Okay.
That the defendant who is a tenant of the plaintiff earlier filed a title suit. Page 21, sorry.
Yes,
Who
yes.
is a tenant
yes,
of
yes,
earlier filed a so and so.
Yes, yes.
That's a clear admission. And para 13 also, my lord. It is.
Yes, yes, now I get it. Huh.
If your lordship will kindly come to para 14, last 3 lines. Moreover, defendant incurred a lot of money in repairing the tenanted premises. Yes, the earlier suit, my lord. Our counterclaim was also rejected by the learned Munsif. Yes. Yeah, possibly the talukdar, not through that now. Pankaj. He was inducted through one Pankaj talukdar.
Earlier case, they have said that Pankaj Talukdar is her financier.
Sublative. But therefore, I'll humbly submit, my lord. Perhaps there was no occasion to frame that issue in view of the clear admission.
No,
Well-
My suggestion is that yes, financier is admitted, no doubt. But what about that without due date? That is important, because they have not also shown what is the due date.
It is neither pleaded in the plain, it is neither pleaded in the revision petition.
Without, otherwise, this is the requirement of law, without law says that before going So going to, that is a matter of law, because even if I didn't, one cannot violate the law, my lord. Or one cannot bypass the law, my lord. That is the. Yes.
Since it is a lordship subject, therefore I have just placed the basic facts. Right. My lord, that's why Supreme Court has said, my lord, it is a voluntary relinquishment of a right or to hesitate or pursue a legal remedy. Waiver. Waiver has been defined. Voluntary relinquishment of either a legal right or to pursue a legal remedy. Yes.
So in my humble submission, my lord, it is their burden, my lord. That is the plaintiff's burden. When if I didn't ask the plaintiff has not discharged his burden, then I have nothing to say. Yes, not ground below. But this is a matter of law and it goes to the root of the matter. It can be taken up everywhere, my lord. Yes, of course, my lord, because this is goes to the my lord, root of the matter. Your question of law can be, my lord, because this is your question of law. And secondly, my lord, the court doesn't get jurisdiction without deciding that point, my lord. This is jurisdictional error, my lord. That can be entertained by your lordship by invoking.
Yes. Deeply obliged. Malum.
Your paragraph, round one was my perversity, my lord, on that perversity, my lord. You're going to-
The overriding thing with the press is that we should have been to 36. The
Time being I think 10. Time being I think 10.
Referring this present. A brief by an order dated 9/2023. My lord will find it page number 20.
Where is the impugn order? So where is the prayer in the injunction application? Where is the prayer?
20 years.
No, the prayer in the injunction application. Where is that?
Starts from 10:30.
अपडेट पूर्व करने किसी को बोल रहे Where is the copy of the agreement? Copy of the agreement?
Will find in page number 82.
Page? Yes, where is the statement? How you came into position?
By giving position. Team Malot, by way of this steel which Malot will find in page number,
Page
it's 65.
65.
Delhi Malot was executed.
65 doesn't relate to possession.
This gives me position.
Where is that? Well, this deed gives you possession. Then this deed is not, cannot be read in evidence. Because you see, section 52, it creates a bar. Unless it's a registered instrument.
Not a registered, but I came in possession.
No, but it doesn't have that clause. Possession is not granted here.
Malot, it is granted now. If I may take my note to 60.
67. Yes.
65 Malot. Point number 9 Malot. You can establish develop. Number 3 states that still this cannot be Malot. Not a registered instrument. I was. Fact, there's a clause, Malot. Really says that. For 10 Malot. I can finish off the construction. Was there because a certain. Plan for the purpose of Malot. Things of the response. He decided to lease out this particular property. I being need of 1 year, I have got. But Pilot may come to number 12 now. It clearly states that if owner number 1 desires to sell this property in future, I shall be the first person to come. As regard to that, I was being communicated their desire. 2018, I have been paying. A chart has been prepared and manual. After execution of this particular agreement, I've also procured electricity connections and proper permissions from the concerned authorities for running that resort. I'm still running that resort. Very unfortunately, they are constantly trying to dispute. Whole intention that
Where's the agreement for sale?
that will find at page number 82.
82.
The position Malot will find at page number. Last paragraph.
But Mr. R. Senswell and counsel for the appellant. Where is the trial court order?
Third part, the last page.
Fine. This appeal under order 43 rule 1R. With this section 150 on CPC is directed against the order dated 22/9/2023 passed by the learned civil judge Nagaon in Nijia case number 101 of 2023 in TS 101 of 2023. whereby notice before grant of injunction was issued. Where is the imminent threat period?
Take my note.
129.
Jackie Road police station. Not take my FIR, so I had. Next page, my lord. Thank you. Directors and party. Names of.
Next paragraph. You should notice on this application, you should notice to the respondents, the delivery in. Give a fixed date, after 5 weeks.
After 5 weeks.
The number is so and so. Next paragraph, the applicant shall take steps
20 to 11.
within 2 days, within the next working day for service of notice on the respondents by registered post with AD. The learned counsel for the petitioner is permitted to correct the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph, the learned counsel for the applicant has paid for identity of injunction. You file an IA? This will go in IA, this one so and so, in IA. IA again, issue notice. The learned counsel for the applicant has paid for an identity of injunction on the order 39 to 1 and 2. Read with section 151 CPC by positing that which has been- you getting the voice now? Application was also by which the applicant is paid for identity of injunction. The issue notice. Next paragraph. The learned counsel for the applicant has referred to the materials available available in the connected memo of appeal, and it's projected that initially the suit land was taken by way of lease on, what is the date? 20? 25 to 25 June, which year? 2013. And thereafter, took possession of the, and thereafter took possession of the suit land, commence his business in terms of this, lease deed. It is submitted that that presently the applicant is running a resort from the suit land.
Click করে মোকা করে ফোন
It is also submitted that the the applicant has entered into a agreement for sale with the respondent number, all the respondents? Respondent one. In respect of the said suit land, at a cost, at a agreed consideration of rupees 1 crore 50 lakh, out of which it is claimed that a sum of rupees 1,03,95,000 has been paid to the respondent number one company, and a balance amount of rupees 46,05,000 is yet to be paid. Is submitted that the respondents are seeking to forcefully evict the applicant from the suit land, for which they had initially gone to the which police station? Jafrabanda police station. As the FR was not received, on 12/9/2023, complaint was lodged before the Superintendent of Police, Nagaon. Next, as it has been projected that the petitioner is carrying out, the applicants are carrying out the business of a resort from the suit land, which is operational, common. The court is inclined to grant identity injunction, restraining the opposite parties, the agents and assigns from disposing the applicant from the suit from property and creating any third party interest in respect of the said suit land. This order of identity injunction shall be operative next para. It is made clear that if steps are not taken within the next working day for service of notice coming, the court may recall this identity injunction on the next date. Okay, list also. Yes,
Item 36.
Because the corporation attachment order was already issued, it will come into effect. My lord, what happened?
you're there for the bank?
Lordship,
Okay.
I prefer adjournment.
Lordship, before my learned friend starts his submission, I'd like to inform your lordship that today the debt checkup, I fixed for checkup of myself before a doctor. Because I had gone on an operation on the
Okay.
19th. Myself.
What
I
had happened
told
to
my
you?
learned friend,
You are such agile person. What happened to you?
I told to him, but he objected.
Okay. That's bad if if Nandi is otherwise, what you call, always there when his matters are called. If he's
No,
having
I
a,
told him that I will be going for my checkup.
Because 16th the last is letters, at least for the time being you.
No.
say,
no, if he's ill, to call him in the
"No,
courtroom.
Just now,
No, he told me that before upgrading the matters, he has not informed me. That is the first thing, he has committed mistake. Secondly, he told me that the matter will be taken up at 3. I had an appointment with the doctor at 5 o'clock. I told him immediately. But now he told me that at any time, I will not go. That is the thing. Thank you.
Because if he's
Okay, you
unwell,
continue submission.
if he's unwell, he has told you.
What are
Yes.
There's a only one simple mistake you have to come, Lakshmi, by the one, there is primary basic apparent defect in the.
But why we should entertain a revision against the order of a DRT? There's an appellate,
Yes, yes, I have been to appellate tribunal, but appellate tribunal, they have, I have annexed all these orders. They have asked me to deposit certain amount, which I have failed to do. That's why they have,
in CRP, I can't do it.
this is the, 227 I have found matter.
In a revision, I can't touch that order. There's no,
Challenging that DRT order, not challenging.
then
I'm challenging the judgment to pass by the DRT judgment.
DRT,
DRT, the order award passed by the DRT. Specific of the DRT. Go. All dictate in the judgment.
in limine, I'll be dismissing it. I'll be dismissing it in limine.
Before your lordship dismisses,
We
this is
will
the
not,
mandatory judgment of the Honorable Apex Court.
we will not
Well,
entertain,
that Mala, just point out, Mala.
we will not even entertain.
There is a mandatory judgment of the Honorable Supreme Court, wherein it is stated, there is a very recent judgment of the Honorable Apex Court, wherein in paragraph, I'll 9, this is also relating to the statutory deposit. Paragraph 9 of the judgment. May I read, Lordship?
No, not required.
There is a mandatory provisions. So the Honorable Apex Court has held the learned Honorable TRHE may waive. And in this case, they have the Honorable on their application, the amount of 50% was waived to 35%. Even then, they have failed to deposit a statutory deposit.
I'm
As
not
such-
challenging the award, not neither I'm challenging the award, not I'm challenging the, only the point, the mortgage, the property which is mortgage, is not a mortgage property.
19.2.
That is admitted in the written statement.
Where is this 19.2 order of
Yes.
the DRT?
DRT order, I'm just giving my lord. Page 4, page 411.
Page 411.
In judgment, page 353, my lord. Page
353.
353, my lord.
Three?
53.
353. Yes.
I'm just read out my lord, first para, second para, third, fourth para. The charter certified amount to be kept alive on the mortgage property, being a plot of land measuring so and so, so and so, so and so, so and so, so and so. So this is not the mortgage property which I have mortgaged. I've already only mortgage and leasehold right, which your lordship can appreciate if your lordship go through the OA filed by the bank, they have himself admitted. This is the point, my lord. So great injustice because if they are going to auction that property, because I have not a property, I have not mortgage, I have only the leasehold, I have a mortgage. Page 99, my lord. And that is what Nandi, I don't know, he knows it. That's why he want to dodge it.
No.
And I'm giving all the things he want to blame on me that he wants to do.
What has happened in the DRT?
DRT, I failed to deposit that amount because of my financial condition. That's why they have dismiss the appeal and
No, Mr. We'll be dismissing it in limine. This will not be maintainable. Once you have approached the appellate tribunal, will not enter into the merit.
no, appellate tribunal order I read 414. Four one four, my lord,
414.
414.
Good.
So for that, this order will not be corrected. It is based on the judgment. And if you goes to page 99, madam.
Once your appeal is
So
dismissed,
22 will lie.
once appeal is dismissed,
Yes, madam.
we will not entertain.
So what is the, 223, if I go to.
I am not entertaining. Whatever is your remedy, you avail. Whatever is your remedy, you avail.
Can you convert it to 23?
I'm not doing anything. I'm dismissing this appeal, this revision at limine. This is what I'm not entertaining.
I know. Why are coming into 27? Because the judgment has to be corrected.
No perversity. That you'll have to challenge in the DRAT. Once you
Because
did not,
judgment, because only that, I'm modeling only the legal part, not the mortgage part.
that is facts. Why should I enter into the facts?
They have
When
mentioned
the-
admitted the return.
When the appellate tribunal has dismissed your appeal, facts I will not reappreciate.
They have admitted their way. In the pleading, they have admitted. When the pleading they have admitted, I just read out my letter, it just goes to page 99, my lord.
It will not go anywhere. Once the tribunal has decided and there is a dismissal order from the
Even their counterclaim was also dismissed. They have filed counterclaim and it was dismissed.
That is a different, it is not.
No, no, no.
Again, not against the property. That is, that is.
Their
different.
counterclaim
No,
was.
no, no, my lord, it's
Finding of
wrong,
fact.
my lord.
What's
It's
wrong?
okay, it's okay, it's okay. Whether,
Wrong submission, my lord.
Why?
whether it's,
Why I'm challenging them, my lord?
whether
The
it's,
counterclaim, I'm fighting, I still, with the
whether
admitted. my
it's right or wrong against DRT, this I am not entertaining.
But DRT, who will then, only this, High Court can only interfere.
Under section 20, the appeal lies before the appellate tribunal.
For appellate court, when the appellate has the note, when it is dismissed for default, or because of that the appeal will lie. That-
The
if I have to
statutory
say
provision is to
what
give,
is
it is
this?
a mandatory provision to submit amount.
I'll say in my order that I have a meeting, I'll be dismissing it. I pass orders in chambers, I have some work to do.
Obliged to.
Because that, if a lot of government vaccine, that there is a remedy. So which will apply. That there is a remedy.
Pardon me?
That there is right, there is a remedy. That vaccine will apply.
Honorable Apex Court have specifically
I
held
am
that
not
is
entering into a
mandatory
debate.
provision to.
There is a misapplied argument. I'll not enter into a debate, but it's a misapplied argument.
Obliged.